what are the obligations of banks and merchants when it comes to card brand obligations?
Thanks, John. My name is Dave Nevada. I'm a lawyer at the Information Law Group, and we do data breach work, including a lot of credit card breaches. So we've had to deal with, we have to deal with these credit card brand rules and processes around fines, penalties, and adjudication. But to understand the whole process, you need to understand the rules of the game ultimately, and this is what this slide is about. Everyone probably in the crowd has heard about the PCI security standard, and that's really the standard that the card brands have agreed on to make merchants comply with in order to protect cardholder information. It's an important part of the PCI fine and penalty process because the failure to meet PCI compliance is what actually is a trigger to fines and penalties and assessments. So that's one piece of the puzzle. Another big piece of the puzzle people are less aware of are the card brand operating regulations and security rules. So each card brand has its own set of, I would say, more procedurally oriented rules around security breaches and what a merchant needs to do in terms of providing notice to the card brands, investigating the breach, and other activities. In addition to that, the operating regulations have a very complex set of rules and procedures for assigning fines, penalties, and assessments. And those are the amounts that retailers now we're seeing are paying on a pretty regular basis when there's been a credit card breach meeting certain thresholds, which we'll get into later. The way this is mainly enforced ultimately is not necessarily through litigation, but through contract. So in this context, we have what I call the PCI contract chain. Obligations in the chain start at the top with the card brand rules, and then merchant banks agree to comply with those rules. And in turn, if you're a merchant and want to process credit cards, you establish a relationship with a merchant bank, and you establish that relationship via a merchant agreement. And the merchant agreement will have certain terms in it that allow eventually, as we talk through the process, card brands and others to collect these fines and penalties and assessments. So in a nutshell, the key thing here is that the merchant agreements are typically very one-sided agreements. I've had to try to negotiate these in the past, and even if you have more than one merchant bank or payment processor involved, it's hard to find terms that are any better than any other processor or merchant bank. Very one-sided contracts that require, for instance, PCI compliance. So the merchant agrees contractually to be PCI compliant. Compliance with the card brand rules. So if a fine or a penalty is assessed, the merchant is agreeing to pay those fines and penalties pursuant to the card brand rules. This is another one that they use for leverage purposes. So if you suffer a breach and there's a fine and penalty assessed, sometimes the merchant will try to resist paying that fine or penalty, maybe cancel their merchant account or take other actions that may be problematic for the processor or merchant bank to recover. The processors can then set up a reserve fund, and as money is coming in through the credit card processing chain, they can take the money out, put it into a separate account until they've collected enough to satisfy whatever debt, fine, or penalty they view the merchant owing. And of course, there's reimbursement and indemnification obligations. So if ever the merchant bank gets stuck with the fine or penalty or assessment, which I'll talk about in a second, they are actually financially liable for them, the contract requires the merchant to pay them back for that. And then finally, if you do, as a merchant, try to get out of the contract, try to stop the processing, go to a new processor, the merchant, banks, and processors can put you on essentially a blacklist. It's like kind of like going into bankruptcy on your credit report. Here, if you go onto a blacklist, no other payment processors or merchant banks will actually agree to use you anymore, and you won't be able to accept credit cards anymore as a merchant. So that's kind of the rigorous and very one-sided kind of set of rules that govern this entire PCI fines and penalties process. Next slide. And this is just a summary of that, really, a quick explanation. So on the right-hand side, if you are a merchant, you have to worry about and you agree to comply with not only PCI DSS, but each of the card brands' security rules and operating regulations, and the names of those are in there. So those rules and regulations can be hundreds of pages long, thousands of pages long, actually, if you really sift through them all. So there's a lot to know and understand, and most merchants, frankly, go into these relationships without any knowledge of what these rules and regulations say about fines and penalties and assessments. And on the left, we have a representation of how the PCI contract chain works. You can see from the top, the card brands impose on the merchant banks various requirements and obligations, and then the merchant banks turn around in the merchant agreement and impose obligations on the merchant themselves. One thing to know that is key here is that ultimately, if a merchant goes out of business, the merchant bank is responsible to pay those fines and penalties and assessments. So they very much desire to get those paid by the merchant before any true financial harm occurs.
Excellent. So, Grayson, so what happens when a merchant discovers that there is a breach or one of the credit card brands suspects that there's a breach?
So the process usually starts from my experience with the card brands notifying a merchant that they've been breached. And that process is called the Common Point of Purchase process, or CPP, where one of the card brands will issue a statement saying, we're seeing a very high percentage of fraud from cards that were processed during a specific time frame at your particular business. And then from there, the process can vary pretty dramatically. In some cases, they simply contact law enforcement, and law enforcement handles the investigation. Sometimes the acquiring bank or the merchant bank will ask them to fill out a questionnaire, and it may escalate or de-escalate from there. A lot of different things can happen. Most of the time, I think, they wind up being required to do what's called a PCI forensic investigation. And that's where I or a firm like mine comes into play. And then the PCI forensics report is issued after an investigation, and it proceeds from there.
Great. Next slide. So, Mark, what must a merchant retain? When must a merchant retain a PFI?
My name's Mark Schreiber. I'm at Edwards Wildman in Boston. We do a fair amount of data breach and related litigation, including on the credit card side. So, in answer to your question, the merchant has to retain a PFI when the brands or the processor tells you to do it. And that can be anywhere along a chain. The merchant, once recognizing a card breach, will have to have notified the card brands. You're supposed to do that immediately or potentially suffer yet additional noncompliance fines. Once you submit that questionnaire, usually a card processor will get back to you. And at some point, there will be a discussion of, is the breach large enough that you have to retain a PFI, meaning an entity like Grayson's who will provide a particular stylized report that goes to the bank and goes to the brands? Or can the merchant suffice with its own forensic investigator? And there's usually a back and forth about that. The larger the breach, the more likely a PFI is required. But we've had a number of instances where we expected a PFI to be appointed, and the card processor indicated that they would take our own forensic report. So just as an aside, what goes in these PFI or forensic reports will largely determine what the merchant's liability and exposure, including fines, penalties, and card assessments, will be. It should not be taken lightly. It should be reviewed in draft form, preferably orally beforehand. One can never be too careful about its content and the ambiguities, the language used, the technology employed, the outcomes, the connection to the PCI standards, and causation all need to be explored with exquisite precision. The name of the game of when the merchant will pay, either in litigation or otherwise, will largely be determined by what the forensic report or the PFI report or both say.
Great, thank you very much. So Dave, talking about the PCI's fines, penalties, and assessments, how are the fines, how are they actually assessed and determined?
Well, to Mark's point, the first piece of the puzzle is the PFI report because it's an input into the whole process on the back end. And each card brand has their own way of doing it. There are some similarities between how they do it. Visa's is probably the most mature system. It's called the Global Account Compromise Recovery Process, or GCAR. And basically there are three types of monetary payouts that merchants may face in this context. First are fines and penalties themselves, and these are typically punitive types of monetary payouts that relate to the fact, essentially, in most cases, the merchant's found to be not PCI compliant. And these can be, depending on the merchant, very small or very big, and it often depends on the specific circumstances. I've seen many for smaller merchants who've suffered breaches get hit from MasterCard and Visa, fines ranging from $2,000 to $5,000 initially, and then for every month that the entity is not certified as PCI compliant, they can get hit with more and more fines and penalties until they certify that compliance. But there are also possibilities in kind of extreme cases for what are called egregious fines and penalties, and I believe in Visa's rules they can be up to $500,000 per violation. And in most cases, the car brands are sort of the judge, jury, and executioner as to when these fines and penalties are going to apply. They can also use these fines and penalties as leverage. If a merchant's not complying or cooperating in a particular investigation, they might find themselves hit with higher fines and penalties. But for the most part, in my experience, the fines and penalties are less worrisome than what we're calling assessments here. So there's two types of assessments overall. There are assessments that relate to operating expense recovery and also card reissuance and fraud recovery. So assessments are a little different in nature than the fines and penalties because really they're intended ultimately to compensate the banks, issuing banks whose cards have been exposed in a data breach. So on the back end, what's all happening here is there's been a breach, cards have been exposed, the merchant is doing an investigation, discovering which cards were exposed. A CAMS alert goes out to alert issuing banks, hey, your card may have been exposed during a breach. Check to see if there was any fraud on that card. The merchant or the issuing banks check to see if there was fraud, report that back to the car brands, and you get an amount of fraud that was perpetrated because of that breach. The reason the issuing banks are participating is because ultimately these assessments, if they're paid, some of that money is going to go back to the issuing bank to cover some of the fraud that they had perpetrated on their cards. So the two types of recovery, operating expense, really relates to card reissuance. So if an issuing bank has to reissue a card that's been exposed in a data breach, they can get, for instance, under Visa's rules, $2.50 per card. And that doesn't seem like a lot, but the issuing banks, they allege in lawsuits that they spend $20 to $50 to reissue a card. So they're probably not getting every dollar back for reissuance. Yet if you have a big breach, if you have a million card breach, 250 times a million is 2.5 million right off the bat just for operating expense recovery. Then the kind of the wild card here, and this is why this is a difficult area in my view, is the fraud recovery. So in any given breach, the amount of fraud that's perpetrated could be anywhere from essentially zero to millions of dollars. You just don't know at the beginning of the breach how successful those the fraudsters were in actually creating counterfeit cards and going out and using those cards to purchase goods or get other types of monetary benefits out of them. So the amount of the fraud here will depend on how big was the breach, how many cards were actually exposed. And then the second part of it is how much fraud was actually on each of the cards that were exposed, and adding those all up will get you at least a top line of a fraud recovery. And again, going to Mark's point, you can influence the number of cards that may be at risk during the PFI investigation to limit your potential exposure, potentially take cards out of the compromised card count that may have actually had fraud on them, and therefore eliminate those cards from the fraud recovery process itself.
And that's very much like the breach scenarios where in some of the forensic examinations, we really don't know how many card numbers were exported. We may know the nature of the malware, we can understand the executable, but we won't necessarily be able to track the cards that were exported either because the data was wiped or encrypted or there's some second-tier malware attached to the attack. And that's where the art form of all of this comes in, that is trying to craft language in the expert report, whether it's a PFI or your own expert, as to whether more likely than not to a certainty, we're never going to reach that level, whether certain cards were within or outside of scope, or whether they were likely exported or not. And there is a fair amount of ambiguity often in those kind of examinations. I don't know if, Grayson, you have any views on that?
Sure. I forgot to tell you who I was the last time. My name's Grayson Lennick. I'm the lead security consultant for PSC out of San Jose. I'm a breach investigator by trade and currently building and running a new team out there in California. So there are certainly some ambiguities. For starters, most of the investigations that the PFIs in the industry are performing are for uninsured clients and for people who have no legal representation whatsoever. I would say maybe 1 or 8 or 1 in 10 actually has some kind of legal representation and are not sort of just swinging in the breeze and on their own through this process. So that's a part of it. But also the PFI investigation, the rules or the items that are reported as part of a PFI are actually laid out for us by the PCI Council. And we don't have a lot of flexibility in what has to be reported. We do have some flexibility in sort of some of our statements about the security deficiencies and things like that. That can, in the case where counsel is involved, can make a big difference as far as how their client is going to be treated. And I understand that there's actually a lot of sort of despise for the PFI community inside of some circles because there are a lot of PFIs out there that are just not doing a very good job. So there's definitely some heartburn when it comes to whether the conclusive or the inconclusive nature of some of the reports.
Which is why we almost invariably recommend that the merchant retain its own forensic investigator at the outset, regardless of whether a PFI will later be imposed.
And to kind of reinforce the point, because there's often ambiguity here, and because this PFI report is the key input into the amount of fines and penalties and assessments you may end up paying, to be able to not take advantage of it, to make sure that the PFIs are not over analyzing the incident in favor of the card brands, and they're taking a narrow interpretation of the various ambiguities so that your card exposure is limited is really the key here and the name of the game. And having that your own forensic investigator, as Grayson laid out, the PFI investigators, sometimes some of them have bad reputations in terms of what they do. Others, in certain cases, only go so far in terms of investigating. To have someone on your team, essentially, who can go much deeper and perhaps discover that certain assumptions made by the PFI are not accurate, and therefore the card's head scope mark should be much less, or the window of intrusion should be a smaller window, is of key importance. One thing I see a lot of times, I get called in when the fines and penalties are being assessed, which is usually 6 months to a year after the breach sometimes. And by then, the PFI report's already out. Your best chance to really influence the fines and penalties has been long gone. Sometimes you can get the report amended potentially. But if you don't bring someone in at the beginning, another forensic firm or a lawyer, then you lose that opportunity, is what it comes down to. And that's when you get into much bigger trouble.
And keep in mind also these PFI reports have a little chart. The card brands require the PFI to identify the PCI violation and also check off whether it caused or contributed to the breach. So in that chart is an unfortunate causation conclusion. And up till now, we've been fairly fortunate in not having these reports disclosed in discovery, but attorney generals, other regulators are increasingly asking for them. And so there's a secondary effect of the PFI report or the forensic report if it goes to the brands, which is it may be used in other regulatory or civil actions, which is a whole other set of problems. So the wording of Grayson's report is a critical feature downstream at numerous levels.
So, Dave, you're talking about, you see about 6 months down the road, you're asked to come in when the fines and the penalties are being assessed. And I talked a little bit in the beginning about the increase in claims in fourth quarter of 2013, where we saw a couple of large breaches. Mark, Dave, have you seen a change in 2014 in maybe the amount and size of the fines, penalties, and assessments, or more scrutiny around that, the reports?
so far what we're seeing is on larger breaches, the fines and penalties are higher, in part because of the recalculation that Visa and MasterCard made. But on smaller breaches, those that straddled this 10 or 15,000 card limit per brand, the fines and penalties seem to be less. I mean, surprisingly small in a number of breaches that were not totally particularly small at all. In other words, these 15,000 limits are per brand, so there may be 2, 3, 4 brands, and the breach may be 30, 40, 50,000 cards. That's not small. And in some of those breaches, the fines have been pretty modest.
When you say the assessments have been small, so you kind of give us a range, monetary range?
$5,000, $10,000, $15,000, not a lot, surprisingly so.
I mean, the ones I've seen, I've had a slightly different experience because I've seen smaller merchants getting hit with fairly, relatively speaking, big assessments. Several $100,000. I had an e-commerce merchant that had only like 160 cards that ended up somehow with 1.5 million of fraud on just that small card set. The thing about this is the fraud variable, because you just never know how successful they're going to be until much later down in the process. So when it comes to fine and penalties for especially smaller breaches, those are pretty consistent. I haven't seen them increase as much. For bigger breaches, it may be different. For the adjudication, the assessments, I've seen them kind of come in at fairly high numbers depending on the situation. And there are a couple of caveats here. So as Mark mentioned, like for instance, Visa, if you have a less than 15,000 Visa cards involved in a breach, you could have $10 million in fraud on 14,999 cards. But if you don't reach that 15,000 threshold, the minimum, you get hit with nothing as a merchant. You're outside of the assessment process. So that's another area where when you do an investigation, if you're getting close to that 15,000 threshold, you want to make sure that the card count was done properly. And I've actually had a case where we were able to get it below it was a 10,000 threshold then, and get rid of a several $100,000 fine because the payment processor miscounted the card. So you have to look at these thresholds. There also has to be $150,000 in fraud for Visa's rule. There also has to be a PCI violation that could have allowed a compromise. Going to your causation point, they don't have to establish that the PCI violation or the failure to comply with PCI actually caused the breach, but if it could have caused the breach, then the assessment process kicks in.
And I think it's interesting to make the point about the ambiguity. I was going to use the exact same example that Dave just gave. In fact, the case that Dave is talking about is one that we worked on together. And as he said, the threshold was 10,000 cards. Normally in a PFI report, I'm required to report the date that the intrusion began, or the date that the exposure began, and the date that it ended. And then the acquiring bank will then turn around and pull all of the cards that were processed during those dates. In this particular case, that range came up to something like 10,450 cards. So really just barely over the limit. But when we actually added in the exact date and times that the malware was installed and then removed, we were able to cut roughly 22 hours out of that window, and that dropped it back down below the 10,000 mark. So that's a very rare case. It's usually either way under or way over, like in the 1.2 million card range. So it's very unusual, but that's the kind of ambiguity that we're talking about, that only legal counsel is going to push that kind of issue.
Plus, you have a number of instances where it's not just card data. Card data may be involved, but there may be other data, medical or other disclosures. And so the PFI report only addresses a sliver of that. You may still have all these other notification obligations in addition to the PFI report.
Great. Niraj,
I figured I'll chime in now.
how are you? Why don't you introduce yourself?
Sure. I'm Niraj Sani. I'm a broker at Willis and E&O and Cyber Practice.
So why don't you go ahead, Niraj, and let the crowd know how you are helping your clients address this exposure.
Sure. So a couple of points on what Mark said in terms of multiple PFI. So we heard different terminologies here. There's PCI, forensic investigator, non-PCI, there's acquiring banks, there's issuing banks. So with all those different moving parts, it makes it very complex in terms of where is the coverage and, at what part is coverage available. And there's definitely ambiguity in terms of when you get a policy, definitely there's intent for coverages on what happens after a credit card breach, but where does the coverage fall? So most markets have some type of PCI coverage, either in form of an insuring agreement separately or an endorsement to the existing policy. And they define the coverage by carving out the contractual liability exclusion. Remember, PCI is not a regulatory requirement. It's your contractual liability with your card brands in terms of what your security guidelines should be based on PCI. And if you don't abide by that security, it's more like an audit, then you're not PCI compliant. And in certain cases, even if you are compliant, you could have a breach. So being PCI compliant doesn't mean that you are immune to a breach. And a lot of cases we've seen recently had the case. So the coverage is granted by carving out any fines and penalties from the contractual liability. Also, damages typically would have some type of exclusions for fines and penalties or any amount which the insured would be not liable to pay. That's carved out as well. So we heard that there's fines and penalties when a credit card breach happens, but that's not as much typically. We heard it was $5,000, $10,000, or $15,000. So why do we talk about PCI coverage so much? Because the cost is not really the fines. It's really the other cost that occurs after the breach. And what is those other costs? It's really, in case of the large breach we heard, and I'm sure everybody's mentioned that a few times, is the card replacement cost. So when there's card replacement cost, it's not really the cost occurring from the merchant itself. It's really the issuing banks who have to replace the cards, and there's some card associated with that for each issuing bank. If they're incurring the cost, the breach did not occur at the issuing banks, so they would go back to the card brands or the merchants. If they go directly to the merchants, there's not much success if they sue the merchant. Okay, we replaced 1 million cards, and you owe us the money for the card replacement cost. So typically, issuing bank would go to the card brands like a Visa or MasterCard and say, can you settle this for us? At that point, it's not really a fine and penalty, it's more an assessment. So if card brands go up to the merchant and say, hey, we're going to charge you $50 million because this was an assessment because there was a breach and all these banks had to replace the card. If that falls into your PCI endorsement, that coverage is really not going to be sufficient in terms of what you were really going for. In the past, when there was no PCI endorsement, that coverage was there as a liability. It was a liability against the insured, and the coverage was granted based on what kind of suits occur, like in case of like Heartland. So the other cost, the B2B cost, would be like, let's say issuing bank sends notices because the merchant doesn't really have any names and addresses of the customers that are coming into their point of sales terminals. Issuing bank would have that information. So if they're sending notices or setting up call centers, that cost is really incurred by the issuing banks or in some cases maybe the processor. So that cost has to trickle down in different ways, and we heard of different acquiring banks, issuing banks, and then card brands. So they have agreements with the processor. In some cases, the processor may hire an investigator, a PFI, to find out what happened. So the processor will incur that cost back to the merchant. So is that cost really a liability to the merchant? Is it really their privacy expenses for notice, or is it PCI cost? I think that's one part that needs to be clarified with what the ambiguity is in the coverage. Anything you want to add on that, John? You covered it all?
Got it all?
One of the things I want to mention is there's always chargebacks. Chargebacks are typically not covered within the PCI. That's usually if you dispute a charge on your credit card that's taken off of the merchant's account. The other thing I want to add is a lot of these charges, let's say if Visa goes after a merchant and says, you owe us $40 million because of the card replacement cost, and the merchant says, I don't have to, that amount can be taken directly from their transactions, like a chargeback. So they don't really have much of a choice than to pay that amount. And it all really trickles to what that agreement was in the first place with their either acquiring bank or the merchant itself.
I have a quick question about insurance coverage. Is anybody, to your knowledge, covering remediation steps as part of the insurance plans when it comes to breaches?
I mean, there's proactive remediation, but I think it's remediation to the extent that the bleeding is stopped, but not to fix the systems. I don't think there's coverage to fix the systems after that.
Okay.
Yeah.
Although that would be part of the PCI requirements, wouldn't it?
Absolutely, yeah. By the time the process is over, the brands and your merchant banks for the clients are going to require that you are back inside of compliance before the process is finished and settled.
And just to be clear about what compliance means, you often hear from merchants in the course of a breach that they were PCI compliant, unquote, which meant they thought they were PCI compliant. But by definition, if there was a breach, there would have to have been some PCI infraction, because if you had unencrypted card numbers you stored, CVV2, you somehow had a vulnerability, that by definition would be a breach of PCI DSS, and therefore the merchant wouldn't have been compliant. So this whole notion of the remediation actually goes much deeper into fixing whatever the scope of the issue was at the outset.
Right. Dace, so I think it's, why don't you introduce yourself, and I think it was an interesting story you told on how you actually found out about NetDiligence and wound up on this panel.
Right. Yeah, and you don't want to put my slide up yet because it's too scary. So I'm a director at Instamed. We're a company downtown here in the healthcare payments market. And I was at jury duty in Montgomery County where I met Barb. She's the regional HIPAA compliance officer for Health and Human Services. And we were just talking anecdotally about things, and I didn't know who she was, and she was laughing and leaning in more on the technology and healthcare parts of, the conversation, and asked what I did. And I said, well, I help software companies deploy secure payment solutions in healthcare. And why is that important today? Instamed exists because there's an increasing trend towards consumerism in payments. Healthcare, decades ago, not too far long ago, was insurance payments. But now a lot of the accounts receivable is collected from us. We don't have the great 100% coverage plans anymore. We have high deductibles. Those are credit cards. So you go to your doctor, you go to your hospital, and that's what you're handing over. Instamed is a cloud-based platform. Think of it almost as two clouds. We're taking on the PCI, we're PCI level 1 certified, so the software companies don't have to be. So those credit cards are going into our cloud-based platform, and we're talking to the banks, and we're moving the money and funding the providers' accounts. The insurance is the same thing. We're a cloud-based platform for insurance processing. We're ENAC certified for both payments and clearinghouse transactions. So that's all I got here.
So,
Here, call me when you need a new auditor.
Great networking, right? So we talk about millions of dollars related to fines and penalties and breaches and records getting stolen. So what actually gets taken?
All right, it'll pop up here in a second. That's it. All right. So
top line.
That top line, that's your card data. So when you take your magnetic strip card and you swipe it, this is instantly read on most every retail computer you've handed that to. This, you can look on Wikipedia what parts of your card are where here. But I'll walk you through it. The 4 and all the 1s is a valid Visa number. And then there's a delimiter, then your last name and your first name. And then there's some service type information. It'll indicate if you're a healthcare provider or some other type of retail business. Then your expiration date, then your super secure CVV or CVN, whatever, the 3 digits on the back, right? That's that 447. This is what you don't want your organizations to have. And if you do have to have this for a second. To be PCI compliant, you need to move it away very quickly. The way the PCI rules are written is you just can't store this data on disk, meaning like you can't save it on your hard disk in a computer. You need to pass it, right? So you can put it through memory, which is the part of the computer that is just zapped out. Well, unless you're a computer forensic scientist and you can scratch it and get it back. But we can only write so many rules, I guess, when it comes to DSS security standards. But anyway, in memory, it just passes on to an InstaMed or whoever maybe the bank, through the software. This is in most retailers' environment. So to be compliant, you need to not keep it. You need to move it out. So to minimize your risk, I heard in the previous panel, segmentation was mentioned. It's to segment this from the rest of your environment. You don't want the same network that your employees are using email on to also be processing and passing this data to, right? Email is a great way to insert malicious software, right? So you don't want them together. But further, so what I do at InstaMed is I work with software companies to give them a secure mechanism to not have to be level 1 PCI certified. InstaMed is. So they can pass us this data and get it out of their environment. These are cloud-based companies, or they have client-server software that's installed onto, a hospital environment. The hospital would want to make sure that that environment for taking those credit cards is separate from anything else in their network. The cloud-based software company, if they're hosting everybody, you're more likely can be assured that they're not connecting their service of software with their company's email. So you have like a higher degree, I would think, of certainty that they're separated. But that's segmenting your network. You want to further and further do that segmentation so that you limit your risk exposure to this data as much as possible, to the fewest number of servers. So the ultimate end to this is not even introduce it into your environment. There are encrypted card devices. Not many are out there. I know, I work with a lot of software companies. But we have a number of clients, especially larger hospital organizations, who purchase dozens, if not hundreds of these to keep the card data completely out of their environment. It doesn't even touch their infrastructure. These devices hold it and encrypt it on the device before that cable reaches the computer. And the device, the device data actually just sends encrypted data that the organization has no way of decrypting. So if there's malicious software, they can do nothing with it. So that unencryptable data, right, in that environment goes to like an InstaMed, and we're able to decrypt it in our environment and pass it on to the bank and approve the transactions and make all this stuff happen in real time. So I just wanted to bring that here, and then also get you thinking about mobile devices that take cards or that you key card data into. Do those devices tend to be used for email? So there's a lot of technology out there growing. There's going to be an ever-growing need to figure out new technology to be able to prevent that data from exposing you to more risk.
And just to give you the flip side of that, there are a number of legacy systems out there that even if, for example, you use a card processor and the merchant says they have no card data, they don't store it, they don't keep it, that is not always true either. Sometimes in the millisecond in which the interval between the card swipe and the number is in what's called volatile memory, that fraction of a second, malware sometimes can reach that. So we've had a couple of cases where that happened, even with a card processor where the client said they stored no card data at all. Grayson, I don't know if you've seen those.
Absolutely. That's my bread and butter. There's really two ways that when you're talking about card present fraud, where we're talking about the track data that you guys see there, there's two places or two ways where that's easily intercepted. Most of those terminals that you see when you hand your card to wait staff at a bar or a restaurant, they're going to walk up to a little terminal and they're going to swipe their card through a very simple magnetic stripe reader. That magnetic stripe reader is usually treated just like keyboard input. In other words, if you were to open Microsoft Word and swipe a card through one of those terminals, you would see that track data. So keyloggers can be very, very effective on those kind of terminals. And then, like everybody's saying, most implementations of payment software, they will transmit authorization data encrypted, but it's the software itself that has to do that encrypting. So you swipe the card, it goes to the central server in the restaurant or in the location, is encrypted by the software and then sent out for authorization. Well, until the software gets a hold of it and encrypts it, it's clear text, and it is resident in system memory, and that's where the memory scraping malware comes into play, which is by far the most common type of malware that we see in these investigations.
Great. So, Tom, if you go to the last slide, we'll let everybody go through their one-liners. If everybody sticks to their 60 seconds, we'll have about 5 minutes from questions for the audience. So, Dave, why don't you go ahead?
All right. Well, I think we may have beaten a dead horse, but mine is work to get the best PFI report possible. If there are ambiguities, make sure that they're not being interpreted against the merchant, and hopefully get them interpreted in favor of the merchant to limit your liability.
Ditto.
All right, Niraj?
I would say always when you're getting a policy, understand your exposures and then get the policy based on what your risk is. Don't just always get an endorsement for PCI because that's everybody else is getting. If you are getting PCI endorsement, make sure there's coverage for what the intent of the coverage is. Most carriers do intend to provide coverage for card replacement costs, so make sure that coverage is either there within the PCI endorsement or otherwise on your liability side. And if not, maybe you have full limits on PCI to avoid any ambiguity.
Go ahead.
You want me to go? So my advice is really more for the clients and customers, the insureds. I said shut down remote access and change your passwords. You're leaving the keys in the ignition with a steal me sign in the window. It's not rocket science that's causing these breaches. It's really very, very simple access. It's remote access and it's default passwords, and that's 85% of what I deal with.
Mine is really, I get no money out of selling encrypted devices, but so from a consumer perspective, I hope the industry can get them. It encrypts before it gets the data to even the volatile memory of the computer. And outside of that, more in the enterprise world, just look to segmentation policies to ensure minimizing exposure.
Great. Thank you very much, gentlemen. A lot of hands going up.
Jane, bunch up. No.
So we've talked a lot about brick and mortar type of PCI transactions. I'm a broker in San Francisco, and we have everything online, right? Software as a service is online, and almost every business outsources their payments to either a software as a service or to a VeriSign. So as brokers, how do I determine when PCI governs my insured's business model? And we're talking to both the retailers that outsource it and also the software as a service providers that will either authenticate it or create some kind of storefront for them. It's hard to determine when PCI adheres to their business model and when they need coverage.
You mean when PCI applies?
Yes, when PCI applies to them.
I think everything I said applies to online retail as well as brick and mortar.
Well, as long as it's electronic transmission or electronic transactions, PCI applies.
Yeah,
There are some
I believe
circumstances-
PCI says if you store, transmit, or process credit card data, it applies, period.
In an e-commerce transaction, sometimes there'll be a payment gateway where the credit cards are delivered directly through the gateway, and the e-commerce company never touches it. In that case, the only section of PCI that applies is 12.8 that governs use of service providers ultimately. So it's more limited scope to be compliant with PCI. If you never touch the cardholder data, you just have to have an agreement in place with the vendor whereby they agree to be PCI compliant ultimately.
But that also depends on what never touch means. If you entirely outsource it, if you have no capacity to store, access, view, transmit, do anything with the card data, it goes to a PayPal, some other third-party entity, fine. But there are a number of systems that are hybrid that do somewhere in the process store the data for however short a time, in which case PCI would apply to that website or the company that operates it or the hosting facility or the combination of them.
Yeah, you got to be careful.
Next. Over
Okay.
to the left. Right over here. Yep.
Right here.
All right, John, it's up to you to tell me who's next.
Very quick question. I hope it's not a silly one, but the PCI compliance rules and everything, I presume they're the same internationally? I mean, whether it's in the U.S. or Canada or anywhere else, are the rules all the same?
Not exactly the same, but very, very similar.
Well, and the operating regulations are different for some card brands in other countries. Yes, there are differences.
Mr. Liu, you have a question?
Just really briefly, could you speak to the, PCI implications for the merchant and acquiring banks and processors as opposed to just at the merchant level?
And the question
Chris,
was,
can you repeat? Repeat
Sure.
the question again?
Could you speak to the PCI, requirements and implications for merchant banks and acquiring banks and processors? And we spoke a lot about merchants, but up the chain, how that works.
I'll talk about part of it and then throw it over to Mark here. So the first thing is, again, if there's a breach of a merchant, the merchant bank is financially liable to the card brands. That's the first key thing to know. So if the merchant can't pay or doesn't pay, then the merchant bank is stuck with the tab. Then there's a case of the processor itself suffering a breach, which is what we saw with Heartland, and they have their own obligations and PCI requirements with respect to their handling of the information that are separate from their merchants. So there's two ways you can be liable as a processor or a merchant bank: responsible for your merchants when they suffer a breach, as well as potentially responsible for your own credit card breach.
And there are a separate set of rules. Grayson, maybe you want to talk about those. PCI DSS applies to merchants. There, I think, is also a PCI, PA set of rules for
PADSS
processors?
for application. No, PADSS is for applications. I think PCI DSS, when it comes to service providers, still goes by the same set of rules, but that's where the levels apply, right? Level 1 through 4, where most of America is a level 4 merchant.
But isn't the processor, he has to ensure that all the merchants have controls in place, like running the security scans and such quarterly? That's a processor responsibility to ensure.
Processors are responsible. Yeah, merchants are responsible for their own security, but the acquiring banks are supposed to be responsible for their merchants.
To have the security in place, yeah.
Okay. And there is going to be, we haven't talked about it, a new set of PCI rules, PCI DSS 3.0, that comes into effect, I think, next June of 2015, which will require, among other things, mandatory internal and external scans and other policies and procedures that are not explicitly detailed in PCI DSS 2.0.
Okay. Two more questions right here. And then I'm hoping this side of the room wakes up a little bit.
This actually isn't a question, it's just a clarification. I'm one of those evil auditors that does PCI assessments. So I'd just like to clarify a couple of comments that were made. PCI 3.0 came into being in November 2013. Compliance to 3.0 is optional this year. It's mandatory as of January the 1st, 2015. The June 2015 date applies to certain techniques and protocols that are used in pen testing. They're currently best practice, but they will be mandatory at that point in time. The question before about who should comply with PCI, anybody that touches cards, anybody. If it's got a Visa, a MasterCard, a Discover, an American Express, or a JCB logo on it, be it a debit card, bank card, or a credit card, you're required to comply with PCI. That's both in the card not present and the card present world. I think the other question was service providers. They're obviously required to be compliant because they're handling cards as an agent of the merchant. The merchant is the person that ultimately has the contractual liability with their acquiring bank for a merchant account.
Yeah.
Okay.
Thank you very much. We have 1 minute. There we go. Last question. Thank you.
What about EMV? And will that change the security requirements?
If every single merchant in the country
Can you
purchased...
define, sorry Grayson, can you define EMV?
Sure.
for the-
EuroPay, MasterCard, Visa, it's chip and pin. EMV is what's commonly referred to as chip and pin. So it's made a big difference in Europe as far as what kind of fraud they're seeing. When it became harder to harvest track data, the hackers just focused more on e-commerce. So they're not seeing any less fraud, they're just seeing a different kind of fraud. The problem in the States is that all the merchants are going to be responsible here for purchasing any new equipment. And most of the merchants out there, they're already into the equipment they have for, I don't know, somewhere between $20,000 and $50,000. So after paying that much for these systems, they're not very willing to go ahead and replace every single card reader, card swiper. And then the other problem is that until every single business in the country or in the world have all switched to EMV, you're still going to have hybrid cards with both a mag stripe and chip and pin, and the readers will still be able to take both. So it's an interesting measure, but it's going to be ineffective until it's implemented worldwide.
I think it's also with the PCI 3.0, if all the other vendors have chip and pin and the merchant doesn't, the liability falls on the merchant eventually in terms of not complying with the chip and pin requirement. So that's what the new I think standing is in terms of. So you in that case they have to do chip and pin and somebody has to pay for it. It's a cost. Who has to pay for it? So.
Great. Panel, thank you very much. Thank you very much, crowd, for your time. Thank you.